rise. The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you. We'll have the appearances. Ms. Polici.
Good morning, Your Honor. The SPO is in the same composition with the exception that Mr. Whiting is not in court today, and the legal intern who joined us today is Mr. John Flaven.
Thank you. Mr. Rees.
No change, Your Honor.
Thank you. Mr. Cadman.
No change, Your Honor.
Thank you. I also note Mr. Gucati and Mr. Haradinaj are both in court. Today we will continue the closing statements in the Prosecutor versus Gucati and Haradinaj case. Yesterday we heard the closing statements of the SPO. Today we will start with the defense. As indicated yesterday by the defense, Mr. Rees will speak today and for some time tomorrow. At least that is the plan. And then Mr. Cadman will have the floor for the remainder of the time allocated to the defense. As said yesterday by the panel, the defense should take into consideration that the panel's questions should last 30 to 45 minutes after each statement. If need be, the panel members may also ask questions during the oral submissions. Before I give the floor to the defense, I note that the panel received the proposed additional evidence yesterday. Mr. Cadman, one question. We did not seem to have received the statement from Iman Kabashi. Can you please disclose it by noon today?
It can be done this morning. It was clearly an oversight.
Thank you very much. On the same issue, in last week's order, we asked the parties to let us know by the start of their submissions on sentencing whether any facts could be agreed upon. The panel varies now this order in part so that it can better prepare for the submissions on Thursday. The SPO is accordingly asked to indicate in an email by close of business today whether it is ready to agree to any facts in these statements or whether it agrees or objects to the admissibility of the statements. If the SPO objects only in part to the admission of some of these statements, we ask the parties to have inter-party discussions before Thursday with a view to finding a solution, as was done in respect of the tendered witness statements of the defense. Depending on the SPO information, the panel will give some guidance on the order of issues to address in the sentencing submissions. Mr. Rees, you have the floor. Oh, I'm sorry, Mr. Potch.
Thank you, Your Honor. Just briefly to update the panel, this morning we already reached out to the defense teams via email in relation to the items disclosed yesterday and with a view to reaching a proposal, and we look forward to more inter-party discussions, and hopefully we can get back to the panel as soon as possible when we have a chance to discuss.
Thank you very much, Mr. Potch. Appreciate the initiative. Now, Mr. Rees.
In any criminal trial, the defendant is presumed innocent until proven guilty. As the prosecution have correctly stated, the guilt of the accused must be proved beyond reasonable doubt. The burden of proving that the defendant is guilty falls on the specialist prosecutor. And that burden remains with the prosecution throughout the trial. Mr. Gucati does not have to prove his innocence. There are, of course, two defendants on trial, and the use of the label "the accused" to collectively refer to Mr. Gucati and Mr. Haradinaj is apt to, if not designed to, mislead. The statement from the prosecution and the final trial brief from the prosecution is littered with examples where it is stated that the accused says this, the accused says that, and it is only through the diligent examination of each and every footnote that it can be ascertained that in fact the words are properly attributable to only one of the defendants and spoken indeed in the other defendant's absence. And what one defendant has stated in the absence of the other should only be held against the maker unless subsequently specifically adopted. It's not enough to try, as the prosecution did, to ask the very general question, Mr. Gucati, between the 7th and the 25th of September, did Nazim Haradinaj say anything in public that you wish to disavow? That was not good enough, as Mr. Gucati answered. Well, Mr. Haradinaj said many things in that long period. What specific parts are you asking me about? Can you remind me? The evidence for and against each defendant is different, and their cases should be assessed separately. On behalf of Mr. Gucati, I will, of course, concentrate on the case against him. Mr. Gucati faces 6 counts. Again, the prosecution case on those 6 counts, and whether the prosecution have proved guilt beyond reasonable doubt on any one of those counts, must be assessed separately, and verdicts likewise reached separately. Now, yesterday you were treated to a rather colourful and partisan approach. I, on the other hand, will seek to take a rather more sober approach, lower the temperature somewhat. I will aim to remind the panel of some of the salient parts of the evidence. Obviously, I can't remind the panel of all the evidence, but of some salient parts of the evidence, and make some submissions about that. But it is, of course, your view, the trial panel's view, of the evidence that counts, and your view alone. And likewise, I will then turn to make some submissions on the law and how we submit an approach can be taken to the counts. And those submissions are designed to assist, but it is, of course, your view, the trial panel's view, on the law that matters, and yours alone. Before I embark upon that exercise, though, I do make one comment, if I may. Talk of the trial panel not allowing the court to fail by effectively not giving the SPO what it seeks, as the prosecution did talk in paragraph 238 of the final trial brief. That, in my respectful submission, demonstrates a lack of professional respect and courtesy on the part of the specialist prosecutor towards this trial panel. This is a criminal trial, and the success or failure of a criminal trial is to be measured only by reference to its fairness towards a defendant, its capacity to afford respect and dignity to all participants in the trial and the arguments advanced on their behalf, its ability to judge the evidence, whether called on behalf of the prosecution or the defense, by the same fair standards, and ultimately whether it delivers fair, independent, and impartial verdicts based only on the evidence and an objective analysis of the law. Whether those true verdicts, fair, independent, and impartial, are verdicts of guilt or acquittal, is irrelevant to the success or failure of this trial, and indeed of this court. And on behalf of Husni Gucati, I do not dare this trial panel to return any particular outcome in the style of the Specialist Prosecutor. I ask only that this trial panel returns true and just verdicts based on a dispassionate analysis of the evidence and the law. The test on any individual count is whether, in relation to Mr. Gucati, the prosecution have proved beyond reasonable doubt whether the elements of the charge, as particularized in the count on the indictment, are made out. Only the evidence admitted during the trial can be considered. So, for example, the reference in the prosecution final trial brief at paragraph 267, footnote 749, to another statement of the Specialist Prosecutor made out of court on the 22nd of September 2020, has not been admitted in evidence. It's not appropriate to have referred to it in the trial brief, and is not, of course, to be taken into consideration. Similarly, the assertion in the prosecution final trial brief at paragraph 22, footnote 47, about a globe icon featuring in Facebook posts and what that might mean. No evidence called trial in relation to that assertion. And similarly, the assertion in the prosecution trial brief at paragraph 24 that the person who made the first delivery was unknown to the SPO. Again, no evidence called by the SPO at trial to make good that assertion. It is not sufficient on any count to establish general non-legal propositions, such as the proposition that Mr. Gucati's stated intention was to challenge or undermine the KSC or the SPO. It is not sufficient to establish the proposition that Mr. Gucati has at some point revealed to another person the name of a so-called potential witness. That is, according to the SPO's own definition, a person likely to have information about a crime, the perpetrator, or important circumstances relevant to proceedings of this court. After all, every person in this room would meet that definition. Nor is it sufficient on any count to establish the proposition, if it has been established, that prosecutors in some historic cases, dating back some 10 to 15 years ago, encountered various difficulties with witnesses, which collectively have given rise to the now well-worn trope of a climate of witness intimidation in Kosovo. None of those general non-legal propositions repeated over and over again by the SPO are indeed sufficient. Let me turn to begin with then to a theme which runs throughout the trial and is central, we submit, to the trial panel's understanding of the evidence. And that is Mr. Gucati's concern about selective justice. It's a theme which runs throughout the trial because it is, Mr. Gucati says, the motivation, his purpose, that ran throughout his actions, his words and deeds in September 2020. Criticism is made that he has expressed the view that the Specialist Chambers is mono-ethnic, or has referred to it as racist and talked of collaboration with Serbia. In the opening statement, the Specialist Prosecutor specifically acknowledged the right to criticize the Specialist Chambers. At page 787 of the transcript, lines 4 to 6, the Specialist Prosecutor said, "It is okay to say what you do not like about this court, and it is okay to say why you do not like this court. That is all part of a free society. Well, Mr. Gucati has expressed his concern about the court, and indeed there are objective grounds to support that view, whether you agree with it or not. And as we have seen from the evidence, many, including many members of the press in Kosovo, share that view. Mr. Gucati has called for justice for all, not some. Can I ask, please, for Exhibit P29ET to be pulled up, page 1. If your honours look to the bottom of that page, we will see in that bottom paragraph under the time 000159, Mr. Gucati said, "We are not against justice, but we are against selective justice." And that neatly sums up Mr. Gucati's position and his concern in relation to this trial. His support for justice for all, as it were, is a position that he has expressed both during the indictment period and indeed before it. Can we look, please, at Exhibit P83ET at page 57? And the English version, please, of P83ET. So at page 57, of 87, we can see there an entry, 18th of July. The whole world knows about the crimes that the Serbian state committed in several countries of the Balkans, including Kosovo at the end of the 20th century. I invite Viola von Kramon, an MEP, to come and witness herself the barbarous crimes which the Serbian state committed against the Kosovo population. But now, instead of punishing the Serbian criminals for the crimes and the violence in Kosovo, there is a trial against the just war of the Kosovo Liberation Army and of the people of Kosovo. I invite Viola von Kramon to visit us at the War Veterans Association of the KLA, where we can tell her the crimes of the Serbian state. We call on the MEP Kramon not to interfere with the activity of the specialist chambers. If she really wants justice, let her come and see herself the evidence of the barbarian crimes committed by the Serbian forces in Kosovo. And the comment immediately below on his page, we call on MEP Viola von Kramon to ask for the creation of a specialist court which would investigate all the crimes committed by the Serbian state in Kosovo, so that the Serbian state is punished for these crimes. He did not call for any interference with the activity of the specialist chambers, but supported the creation of a court which would investigate all crimes committed in the relevant period. As he said at P9ET, please, page 8. At lines 5 to 6 on page 8. Here on the 7th of September now, so at the beginning of the indictment period, as we have said for the last 4 or 5 years, we're against the special court. We are not against justice, but against the special court because of its selective approach. Mr. Haradinaj, in the presence of Mr. Gucati, has supported that call for justice for all. Can we look, please, at P35ET? Page 5 of 15. If your honours look under 001421, in the second paragraph under that time, you'll see that Mr. Haradinaj referred to extending the mandate of this court and said they should consider our proposal to amend the law and enable the court to prosecute all the crimes. The Association of KLA Veterans supports a court to prosecute all crimes. The War Veterans Association is not against solving crimes. In fact, it supports this. It's a position that they set out time and time again. Can we look, please, at P12ET? Again, the same date. You can turn back to page 5, please. And towards the top of the page, this time Mr. Tommy Gashi, but again in the presence of Mr. Gucati, states the KLA's OWV officials, including the chairman, Mr. Husni Gucati, and others, are seeking the undoing of the specialist chambers through legitimate means. And if that proves impossible, if due to certain international agreements, the establishment of the court heralds a certain connotation and international weight, then they seek an alternative normal solution. And that is the investigation of the crimes committed by the Serbs. Let's not separate the Serb crimes from the Albanian ones, but let's investigate anyone who committed war crimes during the Kosovan War instead. We know that 15,000 Albanian civilians were killed by none other than the occupying Serb forces, the Serbian police and army and their paramilitaries, which the Serbian army and police used in order to elude their commanding responsibility. And based on this law, they are not subject to investigations at all. Just think about it. It means that the Specialist Chambers, which is now the only international court investigating the war crimes in Kosovo, does not deal with the crimes committed by the Serbs, and that's a catastrophe. They are allegedly investigated for crimes against humanity, supposedly committed by some members of the KLA, but they do not investigate the crimes against humanity, that horror amounting to genocide that the occupying Serb forces committed here for many years against us Albanians as a national entity. Now, the prosecution, of course, focus to the exclusion of all else, even in their presentation, redacting out words that immediately precede those words and follow those words that they wish to rely on. The prosecution draw focus to the words, Mr. Gucati and others are seeking the undoing of the specialist chambers through legitimate means. But they ignore the context that is repeatedly stated by Mr. Gucati and others, that they seek a court only that investigates all crimes. They are not against justice. As Mr. Gucati said again, if we can look please at P28ET. The first page of this interview on the 22nd September, at lines 14 to 16, please. As far as justice and us is concerned, we are all for an honest justice and not a selective justice or a one-sided justice. Indeed, later at page 11 of the same interview, beginning at line 28, he specifically called on this court, this prosecution, to investigate a particular matter. He'd referred to it on other occasions as well, Your Honours will recall. But we'll see there at line 28. I mentioned in another programme today a debate that I had with a lawyer in the case of Pek Panda. I believe that you know, and he goes on over the page, to say about those 6 young Serbs that were killed. They were citizens of Kosovo, those Serbs, those children, because they were just children when they were killed, somewhere between 15 and 17 years old. Why doesn't the specialist court take up and investigate this case? Because they are saying that we're looking into crimes that the KLA has committed against the Serbs. And the journalist raised the issue about jurisdiction. And Mr. Gucati pointed out, well, they're also citizens of Kosovo. Yes, they are citizens of Peja. Why doesn't the special court consider them to be citizens of Kosovo and look into their case? Despite the fact that they are Serbs, they are citizens of Kosovo. Why don't they look into this case? Why doesn't it deal with such cases at all? He wanted the investigation of all crimes. It was a position he repeated when he gave evidence. Can we look, please, at the transcript of Mr. Gucati's evidence at page T2412? And at line 25, going over the page, but beginning at line 25, he said this: I said that I am against this court, and I remain against it, because this court does not convince us that it is able to investigate the crimes that have occurred in Kosovo. The crimes that police and the Serb Chetniks killed 6 Serbian civilians. This is what I said, and I stand by it. If this court were to investigate crimes in a non-discriminatory manner, and I stress non-discriminatory, only from that point onwards would I be able to extend my full support to this court. he continued, if we go on, please, to page 2428. And if we look at line 15, please. He continued, this specialist court, which has been set up, needs to pursue the crimes committed by Serbia. And I don't think that that is fair and equitable justice. I'm not in seeking to make anyone guilty here because they're doing their own jobs, but they ought to be doing their jobs impartially and to follow every single case in a fair and equitable manner. This is not sophistry from Mr. Gucati. Obviously, it will be for the trial panel to make an assessment of Mr. Gucati as a man, as a witness. One thing you might not think of Mr. Gucati is that he is a man of particular sophistication. He tries to speak as plainly as he can. He has been criticized for using the word collaborate. Can I strike a note of caution when the trial panel considers that word? Whereas, of course, in English, there are two words for cooperation and collaboration. In Albanian, of course, there is only a single word. Forgive my pronunciation, but it's bashkëpunoj. There is no distinction, there is no different word between cooperate and collaborate. But it's a word that he used in answer to Judge Metro as part of his evidence at T2433, please. Line 13, Judge Metro, having continued a discussion with Mr. Gucati about his approach, as it were, to support or otherwise for this court. Your Honour asked, so when you said on public television you wanted to undermine the special court, we must understand you to mean you wanted to advise it. Is that your evidence, Mr. Gucati? His answer was, that is correct, Your Honour. I wanted to advise it, not to undermine and destroy it, but advise it not to collaborate with war criminals, but with people who are witnesses of fact, who have taken part. I'm not against chasing every single case in Kosovo. I am a vehement supporter of justice, and from that point of view, I have been against this court. His position, repeated over and over again, perhaps not in the most elegant of terms, but clear in my submission, is that his objection is based on his concern that this court and this prosecution does not investigate and prosecute all crimes committed during the relevant period. Of course, as part of that, he has expressed concern, as he did there in that passage, with the prosecution dealing with what the prosecution have described in their final trial brief, notorious Serbian officials. People who, and again, there is evidence of this, we've seen it during the course of the trial, in newspaper articles, have been described by the press as participating in massacres during the course of the Kosovan War. And Your Honour, Judge Metro, of course, has made the point, and did so when Mr. Robert Reed gave evidence, that it is not in itself neither unique nor necessarily objectionable for an investigation to seek the cooperation or take information from persons suspected of crime, even very serious criminal offences. And at page T3364 of the transcript, please, Madam Court Officer, Your Honour, Judge Metro asked Mr. Reid about that in his experience. At line 2, Your Honour asked Mr. Reid, in your practice and experience, whether in Australia or at the ICTY, did that happen, that you collected information from individuals you suspected of having committed a crime? And Mr. Reid answered, yes, I mean, in some instances, and this was one of the difficulties that we had, that in some instances, we would be investigating one perpetrator group, and we would have a group of victims. But then there was another team investigating the victims, which were their perpetrator group. And the victims were the other perpetrator group. If you look further down to line 12, you see Mr. Reid continued. And that occurred a number of times where perpetrators would give evidence or give information, and we would corroborate that and confirm that evidence that it was in fact true and correct. And then he gave the best examples, he said, where the accused have pleaded guilty and then give evidence in another investigation. And then, in those circumstances, the information they provided had to be corroborated, as he said, to the nth degree. So yes, of course, it is not unique, nor necessarily objectionable for an investigation to seek the cooperation, seek information from persons suspected of involvement in crime or serious crime. But there's a real distinction in Mr. Reid's answer there to the situation that we face here. Because Mr. Reid's talking about investigating one perpetrator group, where we'd have a group of victims, and another team investigating the victims, which were their perpetrator group. And indeed, he talks about the prosecution of those suspected of crime, whether cooperating and providing evidence or not, because he gave the best examples where the accused pleaded guilty, facing, no doubt, the consequences of their actions, and given evidence, and there, even then, their information would be required to be corroborated to the nth degree. Is that distinction between that situation, which Mr. Reid had encountered in his experience, that fair and balanced process where there's no immunity, where both sides are fully investigated and the information provided corroborated to the nth degree, and those who commit crime, whether they cooperate or not, are required to face the consequences of their actions. It's that distinction, the fact that that fair and balanced process cannot happen, is not happening. That failure to investigate both sides, as Mr. Reid and his colleagues would have done, is precisely the complaint that Mr. Gucati raises. It is, of course, inherent in the law which creates the specialist chambers and the specialist prosecutor's office that the sweeping powers that have been given to the prosecution to inquire into evidence located within the territory of Kosovo without having to seek to rely upon the cooperation of the Kosovan national authorities, but it is no less a valid concern for it. The specialist prosecutor, we know under the law, has powers to summon persons for questioning, collect, examine information and evidence, conduct on-site investigations, order the arrest of a person during the investigative stage within Kosovo. It has the powers of the police with the same authority and responsibility as the Kosovan police within Kosovo. The law specifically requires the SPO to act independently from the other prosecution authorities in Kosovo, but says nothing about Serbia. The personnel, premises and property are given wide privileges and immunities by the law to the Specialist Prosecutor's Office, but only in Kosovo. Orders issued by the Specialist Chambers are given force and effect, but only in Kosovo. A warrant of arrest issued by the Specialist Chambers is given the same force and effect as a warrant of arrest issued by any other Kosovo court. And the Specialist Chambers given primacy within its subject matter jurisdiction over all other courts, but only in Kosovo. It has the power to order the transfer to the Specialist Chambers and Specialist Prosecutor of proceedings and investigations, but only in Kosovo. The fact that that is the inherent in the law, that selective approach, does not mean that the concern about it is any less valid, nor indeed that it is not shared widely, as we have seen, including amongst many members of the press. That legislative framework, it is clear, would appear to have been crafted to ensure that whilst the SPO may, if it wishes, request the cooperation of Kosovan authorities, the SPO is not beholden to them and can act unilaterally within Kosovo. There is no reason why, when the mandate of this court is to investigate crimes committed during the course of the Kosovan War, a war between Serbian state, an aggressive war conducted by the Serbian state in Kosovo, that mandate should treat the Kosovan and Serbian authorities differently. A fair system would be a system in which identical legal powers to act in Serbia as in Kosovo were created. And to the extent that the SPO does not have such powers, it is, we submit, and Mr. Gucati has submitted, and many others in Kosovo, including members of the professional press, have submitted, a fundamental deficit in the mandate of the specialist prosecutor. That the prosecution is beholden to Serbia in its ability to inquire in Serbia into crimes committed during a war of aggression carried out by Serbia on Kosovan soil leaves the SPO and the inquiries it makes in Serbia at risk of an obvious interference and manipulation. Mr. Gucati has, both before the indictment period, during it, and indeed at this trial, expressed his fear of that risk, of the manipulation of evidence as a result of inquiries conducted by the Serbian authorities in Serbia. And it's not a fear, again, that Mr. Gucati holds alone. It's one that's shared, we have heard, by others, including members of the press. Can we look, please, at page 7, ET? And if we look during the course of this interview, the anchor of the interview is a journalist. Again, I apologize for the pronunciation, but I think it's Miss Osmanai. And at 002442 expresses the view, the clear view, Belgrade is known for fabricating facts. That is, again, a neat summary of a position widely held in Kosovo. The fear that the specialist prosecutor and this specialist chambers is exposed through its lack of any investigative power in Serbia, and is beholden to Serbia to make inquiries within Serbia, renders the result of those inquiries at risk of an obvious interference and manipulation. Widely held view. And it is an irony in this case that any attempt by a Serbian official, for example, to fabricate facts, as Ms. Osmani suspects, any such attempt to pervert the course of justice before the specialist chambers by a Serbian official would effectively enjoy impunity. A concern, again, that Mr. Gucati has expressed, that others share, including members of the press. Serbia, we know, does not recognize Kosovan independence, the Kosovan constitution, the Assembly of the Republic of Kosovo, and necessarily as an institution created by legislation made by the Kosovan Assembly under the Kosovan constitution, the SPO itself. And we know that Serbia still claims, despite the reality, that it is the national authority for the territory of Kosovo. A legitimate, fair and independent, impartial legal structure would have required equal recognition in Serbia and Kosovo. It would have provided the SPO with the same powers to act unilaterally in both Serbia and Kosovo, and it would have investigated all offences committed during the 1998-2000 aggressive war conducted by Serbia by persons of whichever ethnicity or affiliation. That selective approach to the investigations and prosecution inherent in the SPO mandate, inherent arising both from the subject matter restrictions that are imposed by Article 1, Sub-Article 2, and Article 6, Sub-Article 1 of the law on the specialist chambers, and also effectively selective because of the SPO's lack of powers in Serbia. Though that selective approach is inherent, it does not explain, although it is mirrored by, the selective approach that the SPO has employed in relation to its own interpretation of the law in this case. Mirrored by a selective approach to the evidence that the SPO has taken in this case. And indeed, a selective approach to the arrest and prosecution of these two defendants when at the same time they allege both explicitly in the case of Mr. Faton Klanaku and Mr. Tomigashi in the indictment, and also name others to have committed offences, some of which have actually appeared at this court in their final trial brief. A selective approach demonstrated not only in relation to the prosecution of Mr. Gucati and indeed Mr. Haradinaj in those circumstances, but also as a selective approach, it would seem, in relation to the press. Mr. Halil Brisha gave evidence, and at the outset, before Mr. Brisha's counsel on the 26th of October 2021, the SPO quite rightly stated that Mr. Brisha had committed no crimes, and the Specialist Prosecutor would not be prosecuting him for anything he did in relation to this case. If we can have a look, please, at the transcript of T1507. At line 6, Mr. Hannon, I think it was, explicitly confirmed in front of Mr. Brisha's counsel, and indeed in public, of course, as we were in open session, they wanted to make clear on the record, on the authority of the Specialist Prosecutor himself, that we will not be prosecuting this witness for anything he did in relation to this case. The nature of the conduct, the limited scope of what he published, and most notably his intentions throughout, and effective actions to protect and return confidential information. No crimes were committed in our assessment. And Mr. Hanning did not seek to dissent or deviate from that clear assertion yesterday in the closing statement for the Crown, for the prosecution. Now, just pause in there, if I may. In relation to Mr. Gucati, the prosecution advances the widest interpretation of the scope of the offence particularised in Count 5, unauthorised revelation of secret information disclosed in official proceedings. Under that wide interpretation that the SPO seeks to convict Mr. Gucati on Count 5, guilt is established on the part of any non-SPO staff member simply by the revelation, they would say, of any SPO document to another person with awareness that the document was confidential. And likewise, in relation to Mr. Gucati, the SPO advances the widest interpretation of the scope of the offence particularised in Count 6, unauthorised revelation of the identities and personal data of protected witnesses, at least in relation to Mr. Gucati, under which they say his guilt is established on the basis that any non-SPO staff member is guilty of that offence simply by the revelation of any name to another person that is contained within any SPO document, with awareness that that name might be of a person likely to have information about a crime, perpetrator, or important circumstances relevant to specialist chambers proceedings. And again, I repeat, that definition, of course, would apply to every single one of us in this chamber. Well, neither interpretation, in relation to Count 5 or Count 6, can be right, because Mr. Brisha has committed no criminal offence. The Specialist Prosecutor says, and we agree, and it is worth considering the full extent of Mr. Brisha's entirely lawful conduct. On the 7th of September on 7th of September 2020, at the KLAWVA offices, Mr. Berisha attended the press conference held that day with a cameraman and was told that documents from the specialist court were present. We look, please, at T1517. Line 16. Mr. Berisha had attended at the KLA War Veterans Association offices, you can see there. And they showed, they said it was unexpected. They didn't expect anyone to bring those documents, but the documents were instead brought in the morning. Those are the documents that they were presenting at the press conference. What did the documents concern? As it was said in the press conference, it was said the documents were from the specialist court. Mr. Berisha told from the outset that they were from the specialist court. We look at page T1523. And at line 16, while he was at the offices, he saw that on at least some of the pages, you can see it from between lines 16 and 19 there, that on at least some of the pages, there was a marking confidential. Mr. Berisha's cameraman began making copies of those documents in the form of a digital image or images whilst they were still at the offices. If we look, please, at T1584. Beginning at line 10 there. So, the cameraman, person of many years' experience, much more experience as a journalist than Mr. Berisha. He began recording the documents. As any other cameraman, experienced one who knew his job, knew that he was going to record to make footage. Continue down the page. Madam Court Officer, we continue down the page, please. So at the bottom of the page, you can see they began making copies of the documents over the page, please. Difficult to give a number of how many documents the cameraman recorded there at the offices. Difficult to give an approximate or accurate number. But perhaps some 10 to 15 minutes duration we can see there, lines 20 to 21. The cameraman was taking digital copies of those documents. If we go over the page, please, to line 25. Sorry, T1585 at line 25. And going over the page, if we look at the bottom there, he was asked, you asked to take the documents themselves, did you not? He said it's a bit problematic. There were many documents, and then over the page, please. He said he asked if he could take some of them to see what they were about. And he took a large number, he said, T1521. Line 2. Difficult to know how many pages it took. It was a considerable number, about 1,000 was his estimate. And indeed, if we look please at T1587, line 22, he confirmed that if he was able, he would have taken all the documents. It's right, isn't it? If you're able, you would have taken all the documents. Yes, correct. Over the page, please, T1588. At line 5, what he wanted to do, he said, was to look at those documents that he had seen were marked confidential, to spend some time considering them. Decided we would look at the documents because it was made possible for us to take those documents, look at them and see what we could report on them. So to look at them and see what he could report on them. And indeed, he physically removed the documents. If we look at T1522, please. At line 21, he described how he took those documents about 2 kilometers away, 1.5 to 2 kilometers away, to the offices of In Focus newspaper, where he presented them in unredacted form to members of the press. Other members of the press, 4 in fact. We look at T1572, please. Top of the page, line 1. The editors and I looked at these documents to see what was in there. So he's seen at the offices of the KLAWVA that some were marked confidential. He's taken them all, though, or as many as he could, and he's shown them to 4 other members of the press who were not at the KLAWVA offices, but were at his offices, the In Focus newspaper office, where he presented them, made them available, invited 4 other journalists to read in unredacted form. If we look, please, at 1598. And line 3. So they were, one of the issues they were interested in was to see whether the documents would shed any light on who had delivered the documents, where they come from. And he says at line 7, for the time that these documents were being discussed, we dealt with that as well. So that was one issue. If we look at T1597, please. And line 21. just confirming there, line 21 to 24, that the documents that he shared, that he took back and showed to those 4 other members of the press, were in the same form that they were when he picked them up from the KLAWVA. Didn't do anything to them. And if we can go to T1607, please. Line 21. There were digital redactions applied later, but that was after he brought the documents back and he'd shared the document in full without redactions with his editorial colleagues. As he said at line 24, every article that was published afterwards came after discussions held with that editorial team. If you look over the page, please, to line 1. And in those discussions, the editorial team had the documents in their unredacted form. The redactions applied later, yes, before publication. Answer, when we decided on what to publish, we also decided which pictures we will publish together with the text. And then he talked about the redactions being applied not by any specific person. No one had a particular role to apply those redactions. While the documents were being examined at Mr. Berisha's invitation at the InFocused offices, more copies were made. Can we look, please, at T1591? And line 1, please. So the documents, if you recall, were spread out on a table in a large room by Mr. Berisha to allow the other members of the press in that room at the InFocus offices to read them. And photos were taken, he said, from the big table that is in the main room in the middle of the office, the open plan office. Images taken that day, the documents spread out on the big table in the main room in the InFocus office, is that right? Must have been on the same day because that was the day when we looked at the documents. And if we look at, please, at page T1623, line 9. He couldn't exclude that after that day, other copies were made. So you're saying, as far as you know, there were no other copies made, but you can't exclude the possibility because you were not in the office 24 hours a day. Is that right? And his answer was correct. Couldn't exclude that possibility. Others had access, of course, they did, to that room. What did the unredacted documents that Mr. Berisha revealed to the 4 other editors contain, according to Mr. Berisha? If we look at T1572, please. At line 6. As we were looking at the documents, he said, we saw there was a lot of correspondence between the Special Task Force with prosecutors in Serbia. And they'd asked them to provide them with witnesses. And there were names and addresses that the Special Task Force had received, but they had not been able to verify their addresses. So this was correspondence between the task force and the Serbian prosecutors in order for them to assist with finding these witnesses and their addresses. So, Mr. Berisha had delivered, physically removed and delivered to a location 2 kilometers away from where he originally picked them up, unredacted documents, which he saw contained at least some that were marked confidential. They contained, when he showed those documents in unredacted form to members of the press, 4 of them, spreading them out on a table in a room in the office. He and the others that he showed the documents to saw there was a lot of correspondence between the Special Task Force with prosecutors in Serbia, asking them to provide witnesses with names and addresses that the Special Task Force had received, and requests to find those witnesses and their addresses. And that does not amount, the SPO agrees, and I agree, that does not amount to the offence of unauthorised revelation of secret information disclosed in official proceedings. Nor does it amount, the SPO agrees, and I agree, to the offence of unauthorised revelation of the identities and personal data of protected witnesses. Mr. Berisha made a distinction between things that were not confidential within the documents and things that were confidential and secret. Those are his words. We look at T1570 and line 12, please. So he, as we can see there in his answer at line 12, had doubts, as did his colleagues, about the authenticity of these documents. And of course, that's a doubt that Mr. Gucati also expressed, and we've seen others also express. But he said this: we decided, in spite of our doubts, that we would publish only things that were not confidential. So not publish things that were confidential and secret. So the distinction between, in the documents he saw, some of which were marked confidential, but what contained in general to be SPO or SITF requests to Serbia to assist with witnesses, providing their names and addresses also, that they would look again at the material, publish only things that were not confidential, and not publish things that were confidential and secret. So the distinction. Some things in that documentation that were not confidential, some things that were confidential. He made a further distinction as well. T1605, please. At line 11. He made a distinction between persons who were public persons, such as Serbian officials, and people who were private persons. So he was talking specifically about the public interest in publishing articles, which I will turn to in a moment. But for these purposes, my concentration is on that distinction between public and private persons. It was in the public interest to do so, he said, because these persons were high Serbian officials and were the persons that a part of the people in Kosovo know due to their statements. So these were not private persons. And since they were mentioned in these documents, we deemed it necessary to publish them their identity. So, 2 distinctions so far. Things that were not confidential, things that were confidential. Names of persons who were public persons, such as Serbian officials, and other people who were private persons. Another distinction, T1609, please. Line 10. He made a distinction between documents marked as confidential and those who are not marked as confidential. Again, we'll look at the specific document that he's referring to in a moment, but here he has said, he's referring to the terms Kosovo and Matoya, which he said is not the correct term, and it's not. But he said this, and these terms have been used in a document or a statement by Serbian officials. And this document was not marked as confidential. And so he published it. So, third distinction. First distinction, things that were confidential in documents, things that were not confidential. Second distinction, persons who were named in a document that were public persons, such as Serbian officials, and other names that were names of private persons. Third distinction, some documents marked as confidential, others not. And of course, we know that he also made the distinction, we've looked at it effectively, the fourth distinction, the distinction between making available the unredacted documents to members of the press, distinguished from publishing documents online, actually making them, putting them up there for the public to read. That, of course, was the fourth distinction he made, because he showed the documents in full, he revealed them in full to his four colleagues, but then having applied distinctions 1, 2, and 3, he then chose what to publish online, and that was not the full unredacted bundle that he made available to the 4 members of press at InFocus offices. Well, what did he publish online? Can we look, please, at P125 at page 4? And in relation to P125, it should be P125ET-2 is the translation. So we can see that he published images of the documents on the left, and this was on the 7th of September 2020 at 14:39 hours. And he reported, we can see, if we look at the Albanian version, can we scroll down slightly, please? Again, you'll have to bear with me in relation to the Albanian, but can we see there the reference to Bashka Punimi in the penultimate sentence? That is translated in the English version that we have here as cooperation between special investigators and Serbian witnesses. So he reported that the document showed cooperation between special investigators and Serbian witnesses and officials being evident in these documents. That information from the documentation was not confidential. it was, he said, in the public interest to report what those documents were about. Still on the 7th of September, at 15:03 hours, so shortly afterwards, he published a further article. Can we look, please, at the Albanian P125? And then the English version, which is P125 ET1. So we can see there an image. There is a document, looks like a coordination request on the first page. If we scroll the Albanian version down, please. We scroll to the next page, keep on going, then we get to the second page, which has a coordination request addressed to Mr. Vukcevic from David Schwendeman, and it is dated the 11th of June 2015, and there are 3 redactions that are applied to it. The redactions appear to be to reference numbers at the very top, and then again the reference number of a case in the penultimate paragraph. But the rest of the document is published in full. And we can see from the English translation that effectively the text of that letter is replicated in the article. The title was Exclusive: How the Special Court Requested Evidence from Serbia Against Adam Jashari, Hashim Thaçi, Sami Lushtaku, Recep Selimi and others. In Focus newspaper has secured evidence by which the Special Investigating Task Force, under the framework of the Special Court, is suspected of requesting evidence and testimonies from Serbia against Adam Jashari, Hashim Thaçi, Sami Lushtaku, Recep Selimi and others. Amongst thousands of exclusive documents obtained by the Infocus newspaper, there is a letter of the lead prosecutor David Schwendeman addressed to former war crimes prosecutor Vladimir Vukcevic, requesting documentation from Serbia. Pursuant to the ongoing coordination of our offices and further to our meeting of the 1st of June 2015, I respectfully request that your office provides us with copies of related cases to terrorism by the organised armed groups committed by the Kosovar Albanians during 1981 to 1999, including criminal offences contained in Chapter 15 of the Criminal Code of SFRY. We request the following documents: indictments, judgments of the first and second incident court, including those of the Supreme Court. Furthermore, we kindly request that the first documentation should be related to the case of, and then there is the redaction, tried in Pristina District Court against the following individuals: Besim Rama, Idris Aslani, Adem Jashari, Jacob Nura, Fadil Kadriu, Nureddin Lushtaku, Sahit Jashari, Hashim Thaçi, Sami Lushtaku, Recep Selimi et al. This is what is stated, the article said, in the document secured by the newspaper, and then they printed the image with only those 3 minor redactions of the letter in full, 11th of June 2015. Applying those distinctions that Mr. Berisha made, he published it. He made the full document unredacted available to members of the press at the Infocused offices. He then saw that that document was not marked confidential, and it is not. Material within, not something that was confidential, and referred to the names of Mr. Vukcevic because they were public persons, not private. And when he did so, he committed, the SPO agrees, and we agree, no offence of the unauthorized revelation of secret information disclosed in official proceedings. And when he did so, He committed no offence of unauthorised revelation of the identities and personal data of protected witnesses. The SPO agrees, and we agree. He was asked why he published that. And if we look at T1612, please. At line 7, he was asked, why was that, in your assessment, in the public interest to publish? Yes, he said, at that time, the indictment against the then President Hashim Thachi and other people was mentioned. And he's referring there to the fact that although no confirmed indictment existed, the fact that an indictment had been filed had been revealed publicly by the specialist prosecutor. But, he continued, it was never mentioned that that evidence was being sought against Kosovo's hero, Adam Jashari. So when we saw this in these documents, we thought this was in the public interest to know about, because Adam Jashari at that time had been killed by the Serbian forces, and I believe Kosovo citizens were expecting evidence to be collected against those who killed Adam Jashari, and not on Adam Jashari. Pausing there, he was repeating, wasn't he, the concern that Mr. Gucati has, that others we've heard in this trial share, and indeed we can see Mr. Berisha shares. Concern of selective justice. I believe Kosovo citizens were expecting evidence to be collected against those who killed Adam Jashari, not on Adam Jashari. He continued at, next page please, line 19 I think. He was asked why he quoted directly from the letter, why that quote was in the public interest, and he said, Adam Jashari and over 50 members of his family, including young infants, were massacred by the Serb forces. So we as citizens and journalists expect that evidence be collected against that massacre. And it was very strange to us that facts are being collected on Adam Jashari in the context of organised terrorism and armed terrorism. Again, his concern shared by Mr. Gucati. At the heart of everything Mr. Berisha did and said, and at the heart of everything that Mr. Gucati has done and said, is that concern about the selective approach to justice from the SITF, the SPO. After publication of those two articles, it's right that Mr. Berisha emailed the SPO on the 7th September at 16:26 p.m. in which he asked about the information leaked to the KLA-WVA. He didn't say in that email that he had a copy of the documents himself. If we can have a quick look at it, it's P98.1.
Mr. Rees, after this, we will take our break, if that's convenient at this point.
So the email 7th of September at 16:26. And you can see, after describing briefly what he understood to be the documents, nature of the documents, at the two questions at the end, he wanted to know about whether the SPO were aware and would they harm investigations from the SPO, and whether the SPO were investigating the leakage of documents, and what would happen if non-edited documents were published. So not not concerned about publishing edited documents, but non-edited documents being published from media outlets. He didn't, of course, say that he had a copy of the documents himself, but he had very publicly made it clear he did, because we've seen in the earlier articles, he'd actually published, in the first instance, the batch that he had spread out on the table and a picture of it, and indeed, in the second article, he'd actually published the coordination request almost in full, save for redacting the reference numbers and the case name. There's a later article that he published on the same day. I'll come to that after the break, Your Honor.
Thank you, Mr. Rees. We will reconvene at 11:30, and we're adjourned until then.
All rise. All rise.
Be seated. May proceed, Mr. Rees.
Thank you, Your Honour. Mr. Berisha then published a further article which we have at 1D2 as well as at P129, but if we can look at 1D2 first, please, simply because it's a more legible copy. At page 61 of 67. And Your Honour will recall that this version of it actually dates to the time which Mr. Berisha was given evidence. It's still publicly available, as it were. If we zoom in on the time and date, we can see 7th September 1708. And if we just scroll through the document, we can see that there are images published in full, just pause in there, of full coordination request number 63, unredacted. And it's addressed to Mr. Vukcevic. Pursuant to the ongoing coordination between our officers attached, please find a list of persons the EU Special Investigative Task Force, SITF, would like to interview as witnesses in the near future. Although the last known addresses of the concerned individuals are in Kosovo, I should be grateful if your office could provide current addresses, telephone numbers, any other contact information that may assist in locating the persons named in the attached list, as it is believed that they have sought residence cards or Serbian citizenship. Furthermore, I respectfully request copies of all previous statements provided by those individuals to Serbian judicial and police authorities. I look forward to continuing our ongoing cooperation. Signed by Kwai Hong Ip, apparently. And then at the bottom of the page, there is a reference to an attachment, which is said to be a confidential list of witnesses, dated the 24th of September 2014. But the letter itself not marked confidential. And if we scroll down, please. Pause in there. We can see a image of coordination request number 120 published by Mr. Berisha online. And this has what appears to be details of 3 persons redacted, as well as redactions applied to the penultimate paragraph. But the letter is published without redaction to the following information. Dear Mr. Vukcevic, coordination request number 120. Pursuant to the ongoing coordination between our offices, the EU Special Investigative Task Force, SITF, hereby seeks your assistance in locating and providing contact details for the individuals listed in the table below. Based on our most recent information, all of these individuals are currently residing in Kosovo. However, in the past 3 years, they other ethnic communities in Kosovo and Metohija. 15 number, it says, 17th November 2015, Belgrade. Special Investigative Task Force is the heading. Dear Sir, Madam, I would hereby like to inform you that the Committee on Kosovo and Metohija, in the meeting held on the 19th of October, has established by decision, establishing the working group for gathering facts and evidence, elucidation of the crimes committed against members of the Serbian people and other ethnic communities in Kosovo and Metohija. The working group believes that it can contribute to the successful work of the Special Investigative Task Force.
Mr. Rees, please don't read the name that's at the end of that. It's not. As far as we know, it is still a protected name. You read some names in the previous letter that were probably going to have to be redacted as well. The fact that you don't think it's protected doesn't mean that we have made a finding that that is protected, not protected.
I am, of course, as always, in the hands of your honours. The letter continued to refer to establishing successful relations and cooperation aimed at the revelation of crimes committed by the so-called UCK, is how the chairman of the working group referred to the KLA. And that letter, published in full by Mr. Berisha in his article, those three letters published in accordance with the distinctions that he made, we say quite properly, distinction between things that were not confidential within the documents and things that were confidential, distinction between persons who were public persons, such as Serbian officials, and people who were private persons, a distinction between documents marked confidential and those that were not, like that letter from the chairman of the working group, and a distinction between making available the unredacted documents in full to the four members of the press at the In Focus offices, as he did, and publishing them online when he redacted confidential material from them and published the rest. And when he published that article, he committed no offence of the unauthorised revelation of secret information disclosed in official proceedings. The SPO agrees, and we agree. And when he published that article with those three letters, with all the details, including the name of the chairman of the working group, he committed no offence of the unauthorised revelation of the identities and personal data of protected witnesses. The SPO agrees, and we agree. And he explained why he published that article at T1603, line 20, please.
The interpreters kindly ask the counsel to slow down when reading. Thank you.
So he said in relation.
Kad je reč o objavljivanju tog članka sa 3 pisma, on kaže da su ta pisma u celosti objavljena. Apologies.
Published in full, save for those redactions of the names of private persons, not public persons. He said, "We thought this was a public interest, given the past of our nation, the people of Kosovo. Maybe I am young by age, but I experienced war as well. I was 6 years during the war. And at that time, I, my family, and other citizens were forced out of our apartment of our house, we were forced to travel to Albania. What I'm saying now is lighter compared to what others can say. As a 6-year-old, I had to walk to Albania without food, without water, and Serbian forces have put corpses of dead people on the way. And for me, as a 6-year-old, was horrifying. So this is a theme that is discussed on a daily basis in our parts, and this is why we thought this was of public interest. Reporting on this issue was of public interest. And specifically in relation to the names of, for example, the chairman of the working group that he published in full. If we look at line 11 of page T1604, sorry, can we reduce to fit, please? Maybe a mistake with the reference. Can we look at the next page, please? Thank you. It's my fault. It should be reference T1605. And at line 11, please. When asked about referring to the names of, for example, the chairman of the working group, he said that it was in the public interest to do so because these persons were high Serbian officials and were the persons that a part of the people in Kosovo know due to their statements. So these were not private persons, since they were mentioned in these documents. So we deemed it necessary to publish their identity. And when he did so, he committed no offence of unauthorised revelation of secret information disclosed in official proceedings. The SPO agrees, and we agree. And he committed no offence of unauthorised revelation of the identities and personal data of protected witnesses when he published that material online. The SPO agrees, and we agree. Those 4 articles preserved confidentiality and did not disclose any sensitive information, Mr. Berisha maintained. P129ET, please. So page 2, please. If we zoom in, bottom paragraph, Mr. Berisha on the 9th of September, an article set out that the articles that they published on the Monday preserve confidentiality without disclosing any sensitive information contained in the documents, and we agree. And the SPO agrees. And if we look at page 3, again, on the 9th, in this article, again in focus, at the bottom of the page, refers to the articles they published on the 7th of September. They were published without violating any sensitive information. And the SPO agrees, and I agree. The publication of those articles with those letters in full, save for the minor redactions in relation to case numbers and the names of private persons, but the publication of the rest of the information in those requests and the identities and professional positions of both the MP official from Jagodina in coordination request 120 and the name and position of the chairman of the working group of the Serbian Committee for Kosovo and Matoya, as they call it, did not violate any sensitive information. We agree. Just like Mr. Berisha, Mr. Gucati only gave access to the documents to members of the press. Whereas it is asserted by the SPO at paragraph 66 of their final trial brief that access to the KLA WVA might have meant that someone else, other than a member of the press, might have seen those documents. Well, there's no evidence at all, that anyone other than the press accessed those documents. The SPO acknowledges at paragraph 144 of their final trial brief that, and I quote, during the charged time frame in their testimony, the accused stressed that they were never saying witness names and directed the media to do the same. And then described that position as a sophistry, in denial of reality, or at another stage, they think they refer to it as semantics. It is no sophistry, nor is it semantics, to make a distinction between giving access to unredacted documents to members of the professional media with their own professional and ethical obligations, and at the same time insist that they did not publish witness names. That is the approach, the distinction that Mr. Berisha himself made. It's a distinction that Mr. Berisha lawfully made also. And indeed, as it happens, it's a distinction that the panel may recall Miss Anna Myers drew also, between, as she put it, the nuclear option of full public disclosure and the distinction of instead going to the press. As she noted, press and journalists have their own duties of confidentiality that are clearly defined. It's part of their role to understand them. That is the position, the distinction that Mr. Gucati made, and indeed Mr. Haradinaj made. Can we look, please, at P1ET? And this, I think, is the transcript of the first press conference. And if we look at page 4 at 000943 seconds, can we look, please, at the next page? In fact. Just bear with me, please. If we go back to page 4. And, in fact, I was right. Under the section 9 minutes and 43 seconds. In the last paragraph, in the second line, Your Honours will see Mr. Haradinaj, in Mr. Gucati's presence, state clearly, we will not take this material out in the street. They were making it available to the press, but they would not take the material out in the street, they said. And at 11:21, so in the next page, please, the journalist that is referred to there invited Mr. Haradinaj to read for the public, it seems, names. You can see that from the question following on from Mr. Haradinaj's comments immediately before. And Mr. Haradinaj, to that invitation from the journalist, answered no. Those who allow these documents to leak should know that. Now, Your Honours, of course, will look at the material in the round. I, of course, accept that. And Your Honours will look at all the material in its context. But I do urge Your Honours to look at the material in its context and not selectively. And when Your Honours do look at the material in its context, Your Honours should take notice there of Mr. Haradinaj's clear statement, we will not take this material out in the street, and they did not. There's no evidence that they did. And when he was invited by the journalist to read out names of witnesses, he said no. Those who allow these documents to be leaked should know that he wouldn't read out names of witnesses. He was repeating, wasn't he, the same distinctions that Mr. Berisha made, a distinction between making available the unredacted documents to members of the press and publicly publishing information. That distinction? And he was making the distinction, was he not, between persons who were public persons, such as Serbian officials, and people who were private persons. And in the second press conference, again, when Your Honours look at the evidence and look at all the evidence and look to see the context, Your Honours will see at page 2, Exhibit P2ET, please. You will see what Mr. Haradinaj said in relation to the suggestion of intimidation. Page 4, please. He addressed anyone who might be thinking of intimidating anyone. It's in the 5th paragraph. Those who think of intimidating anyone, they will say that we have the files, we know their names. They are anti-nationalist people and people who do not love Kosovo. That is what he was saying about the suggestion of anyone who was thinking of intimidation. They are anti the people of Kosovo, people who do not love Kosovo. And the press were repeatedly exhorted by Mr. Gucati and Mr. Haradinaj and Mr. Gashi also, to protect the names of the witnesses that were contained in the documents that were made available to the press. Can we look, please, at P4ET? At page 9, at paragraph 4 on page 9, Mr. Gashi, in the presence of Mr. Gucati, addressing the media, said, the end of that paragraph, even if you have come and you have had access to these documents, it is strictly prohibited to publish the names of witnesses. The press were only to publish what they were told, again, repeatedly, we say, what they were able to publish. Page 12, exhibit P12 ET, please. At page 3 of 7, just after 00718, tape counter, Mr. Gashi, again in Mr. Gucati's presence, repeated, everyone, including the chairman and others, have always stated to you and them that whoever had access to the information contained in those documents, that is, the name of witnesses, be them ordinary, protected or anonymous witnesses, should not be published. And that's right, they had. And at P35ET, please, Mr. Haradinaj repeated the same. At page 12 of 15, at 002340 tape counter time, a journalist in the press conference, this is the third press conference, and this is the last, said, you're suggesting to us, the media, to publish these documents. Mr. Haradinaj's answer was, whatever you can. What you can. He's repeating even the last press conference, the same position that they set out from the off. We're not going to make the documents public. They were not going to take the material out in the street. They were making it available to the press, who they knew had their own professional obligations, and who, like Halil Berisha, looked at the documents to see what they were able to publish, And they did publish, for example, 3 letters in full. We saw Mr. Berisha, save for redactions applied only to the names of private persons, as it were, making distinctions between whether documents were marked confidential and those that weren't, between whether the information within the documents were confidential and that which wasn't. And Mr. Haradinaj is repeating that position again there in the final press conference. In cross-examination of Mr. Gucati, he was asked questions about a later exchange, right at the very end of this press conference, the very end of the indictment period, about a discussion about fake veterans, which we see at page 13 of P35VT. And the whole exchange begins, we've just seen Mr. Haradinaj already stress to the journalist who asks, are you suggesting to us to publish these documents? And Mr. Haradinaj confirms only what they could. And immediately before the exchange about fake veterans, we can see Mr. Gucati again repeating at the bottom of the page, just under 002523, about a person's privacy is to be protected. We can see that. Then the exchange that took place about fake veterans, well, the SPO, in our submission, misread what Mr. Gucati was saying thereafter. It's the next page. We can see there Mr. Gucati again invites, as he's done throughout, the press to read the documents, but he doesn't say to publish the names. What he says about fake veterans is he was criticizing the press for how they previously published the names of so-called fake veterans, as Mr. Gucati put it in evidence, in circumstances where he was effectively being provoked by them. But he had stressed throughout that exchange, like all the other exchanges, of course, and all the parts of these recordings that I refer to. I acknowledge, of course, your honours will read it all and see the context, put them in context, and come to a fair evaluation of the evidence rather than selectively focusing, for example, simply on those parts that the SPO say are wish to focus on. But I submit that when you look at all the evidence in the round, they have been consistent throughout, that they made those same distinctions that Mr. Berisha made. A distinction between making them available in a redacted form to the press, for them to look at, to see what they could publish using their professional judgment, applying their professional ethical obligations, looking to see what in the material was marked confidential, what wasn't, look at the content to see whether the content was of confidential nature or whether it wasn't, to look at whether the persons are public persons like Serbian officials or private persons, and making the same judgments that Mr. Berisha made, quite properly, in relation to those articles that we've seen and the letters that he published in full, save for the redaction of details in relation to private persons. And Mr. Gucati's understanding of the law, we say, is consistent throughout, and consistent with Mr. Berisha's. And it seems, although there is, I accept something of an inconsistency here, or a contradiction, consistent with the SPO's understanding of the law, at least in relation to Mr. Halil Berisha. And they publicly stated their understanding of the law. At page Sorry, Exhibit P2ET, please. At page 4 of 11, this is the second press conference. And again, it's consistent with what was said in the first press conference, but here confirms that by this stage, the KLAWVA had taken legal advice also. If we look at the second paragraph on this page, Mr. Haradinaj, again in the presence of Mr. Gucati, this conference obviously. We discussed it with our lawyer. We've hired a lawyer in relation to this, and he told us nothing is punishable if we do not mention the names. We're not mentioning names, and it says the Netherlands did not mention it. I'm not sure what that means. But this is where they are. We're not mentioning names. This is where they are. I do not think that it is a criminal offence to reveal the names of the officials. I mean, Williamson, Schwendemann, these are official people. We're not talking about individuals here, never given their names. Given their names, sorry. So again, it's that same distinction that Mr. Berisha made. Distinction between persons who are public persons, like the officials, and people who are private persons. They weren't mentioning those names. Exactly the same distinction that Mr. Berisha makes. And the following day, that lawyer, Mr. Gashi, repeated again in Mr. Guzzati's presence his advice. Exhibit P4ET, please. At page 2, if we go down, please, in fact. Under tape counter time 0004, Mr. Gashi, in Mr. Guzzati's presence, line 3 said, "I think that the publication of these documents is not prohibited at all, but you must bear in mind that if you find information that contains names, surnames, and other data of the witnesses, you're not allowed to make them public in any way. It is not prohibited to publish the relations between officials of the Specialist Prosecutor's Office or Specialist Chambers with Serbia prosecution authorities." That's exactly the same distinction that Mr. Berisha made. Distinction between things that were not confidential in documents and things that were confidential in documents. Distinction between persons who were public persons, such as Serbian officials, and people who were private persons. This is now the advice confirmed by Mr. Tommy Gashi, the lawyer for the KLAWVA. Continued, I think, next page. In fact, if we go right to the very bottom of the page before, sorry. There we are. Pause there. Thank you. Last sentence. I reiterate, he said to the media, that you should be very careful to not publish eventual names of the witnesses you may find in the documents, because this is prohibited. It's illegal and punishable. However, you are free to publish what happened between official institutions, the communication between them to the detriment of former members of the KLA. And that's exactly the material that Mr. Berisha, for example, published. So he didn't have that advice from Mr. Gashi, but that's the approach that he took. It's the approach that Mr. Haradinaj and Mr. Gucati expressed in the first press conference. It's the approach that they were advised about before the second press conference we saw from Mr. Haradinaj. It's confirmed now, again, the day after the second press conference. And at page 7, Mr. Gashi again comments. At the end of the paragraph under tape counter time 001432, for this reason, I said it's not prohibited to publish the communication between institutions, but in no way should you publish the names of witnesses if you find them. Please erase them, do not publish them as it is prohibited. And indeed, P7ET, please. This is now the 18th, page 15 of 19. Under tape counter time 002539. This is Mr. Gashi again. In the presence of Mr. Haradinaj, not in the presence of Mr. Gucati on this occasion, but what he says is simply consistent with what Mr. Gashi has said his advice has been throughout, and indeed what Mr. Haradinaj and Mr. Gucati thought from day one, and indeed exactly the same approach taken by Mr. Berisha and the press. We have said it 100 times, and we're saying it again, one cannot disclose the name or identity of any witness. If the KLA War Veteran Association is in possession of official communications, as it was on 2 occasions of an institution, i.e. the War Crime Prosecutor Office, whose chief prosecutor's name we've learned by heart, the association is not prohibited to publish them. But witness testimony should not be published because that is harmful. I don't know what else to say. So, applying those same distinctions, the Berisha distinctions as it were, distinctions between things that were not confidential in the documents and things that were confidential. And there, as an example, Mr. Gashi's talked about actual testimony of witnesses, and no suggestion that that's ever been published by anyone. And again, the distinction between persons who are public persons, serving officials of the War Crime Prosecutor's Office, for example, and people who are private persons. And indeed, it follows, does it not, from Mr. Gashi's view, exactly the same distinction Mr. Berisha makes between making available the redacted documents to members of the press because, no doubt, of their individual ethical and professional responsibilities, the duty of confidentiality that Ms. Anna Myers referred to, and the press actually publishing documents online. The understanding of the law, Mr. Gucati's understanding of the law, is consistent with, it's reinforced by how the press acted, how Mr. Berisha acted, and other colleagues of his. And I don't need to take you through every press article we've seen, but it's exactly the same approach taken by the other press houses, Gazette and Newborn, and so on. And it's reinforced, at least from after the first press conference, by legal advice from Mr. Gashi. Now, I know that the prosecution in their closing statement and their final trial brief refers to an answer by Mr. Gucati saying that, referring to the second press conference as being the point at which Mr. Gashi became involved, but actually they ignore the earlier evidence where he said that both before and after he became our lawyer, he was given advice. We look at transcript T2389. And we look at line 11. He was in contact with Tommy Gashi on television debates. So, for example, he heard Mr. Gashi express his view both before and after he became a lawyer. You can see that at lines 11 to 12. And in fact, if we look at page T2393, at line 15, Mr. Gucati had said that, in fact, they'd authorised Tommy Gashi after the first press conference. It's then that we hired him as our lawyer, and that, in fact, is consistent with actually the contemporaneous records that we've seen, because Mr. Haradinaj, during the second press conference itself, refers to having taken advice from the lawyer. And just as an aside, I don't want to be distracted too much from the thread, as it were, it is something very noticeable about the SPO's approach to the evidence, that when, for example, an SPO witness expresses, as Mr. Daniel Moberg did, confusion between separating out exactly the chronology of events and saying, I can't remember whether events took place in the second meeting or the third meeting, that is waved aside as of no consequence when, in relation to the defence, witnesses, any inconsistency at all is seized upon, as if it is of some great significance. That's an aside. As I said at the outset, of course, I have no doubt that the trial panel will judge the evidence, whether called by defence or prosecution, by the same fair standards. But whenever the advice is given, it reinforces the understanding of the law that Mr. Gucati had expressed from the outset, and Mr. Haradinaj had, and the press had demonstrated, as Mr. Berisha clearly elucidated. And that understanding of the law, in fact, that if you abide by those distinctions that Mr. Berisha neatly encapsulated, the four distinctions, that there's no offence of unauthorised revelation of secret information disclosed in official proceedings, and no offence of unauthorised revelation of the identities and personal data of protected witnesses, as the SPO agrees, and we agree. That understanding of the law was reinforced by the contact that was had with the Specialist Prosecutor's Office, the investigators from the Specialist Prosecutor's Office, after the first and second press conferences. Now, pause there. The SPO, of course, placed great reliance on the service of two orders upon the KLAWVA, one of which not served on Husni Gucati, the second, they say, was served on Husni Gucati. Both documents, of course, served in English only, with no Albanian translation until after later dates. And to suggest, as the SPO do, that Mr. Gucati can speak English is a misleading interpretation of what the evidence actually was. What Mr. Gucati actually said at T2169 is at line 23, and this is the reference that the SPO rely on. It's the only reference. Can I just check the page number, having said that? 2169? So we see there, do you speak English? No, I don't. I don't speak English. There is a later reference, sorry, where that the SPO rely upon, where he says, he's asked the question, do you read English? And the highest he puts it is, to tell you the truth, I don't. Very little, almost not at all. To suggest that is an admission that the trial panel can properly rely upon, that he could read English to the degree of being able to understand those orders, to read them and understand them, is, we say, far-fetched. But what do the orders actually say? One, they don't say that any criminal offence had been committed through what took place in the press conferences on the 7th and 16th of September. They weren't arrested for anything in relation to those press conferences. The documents we know had been left with the KLAWVA overnight, after both the first and second press conferences, during which, and we don't need to go through the detail of what was said in those press conferences, but at the very least, it was clear that reference was made to official communications between Serbia and the specialist chambers in relation to investigations, and names, indeed, of Serbian officials were mentioned in the first press conference, which the SPO knew at the time that the order was obtained after the first press conference. But no witness names, no private persons' names being mentioned. So to the extent that the orders were understood, they reinforced the understanding of the law that Mr. Gucati had at that stage. Indeed, they were told that it had been recognised that they hadn't disclosed names, and they were thanked for it. So, at 1D3T, please. In the statement of Mr. Gucati, paragraph 39, and this was the first occasion that Mr. Gucati had actually spoken to an official from the SPO about this. So, am I able to refer to the officers' names, Your Honour?
No, you may not.
Well, can I deal with it this way then? Your Honour will recall the Swedish officer. If I refer to the Swedish officer as A, and I refer to the other officer, who is referred to by initials in 39, paragraph 39, I'll call him B. So, Your Honours will recall that A couldn't speak any Albanian, and didn't say anything, and couldn't understand what was being said during the interaction between Officer B and the members of the KLAWVA on both the second and third visits. The Officer A, because he just couldn't understand what was being said, couldn't help at all about what was being said. And Your Honour will recall that Officer B was never called, despite being in invitations from the defence and indeed from the trial panel to the SPO to call Officer B. They refused to, for inexplicable reasons. So we never actually heard what B has got to say about these matters. So the only evidence about what was said comes from Mr. Gucati. And Officer B said that he'd been following the news, and he thanked Mr. Gucati for not disclosing any names. He He said this on both the second and the third occasion when he came to collect the files. He said, it's good that you did not mention any names in public. So what he was told by the SPO reinforced his understanding of the law, same understanding that was shared by Mr. Berisha, reinforced when they got legal advice, which was exactly the same, that you make a distinction between things that were confidential and not confidential. Look at whether documents were marked as confidential or whether they weren't. The distinction between making them available to the press in unredacted form and actually publishing them online so that the public could read or see them. And a distinction between public persons, such as Serbian officials, who weren't named in the first press conference, and Officer B was following the news, and he was obviously of the same view, and persons who were private persons, because they didn't mention those witness names, private persons' names, as it were. And they did not tell Mr. Gucati, either on the first, no one on the first or second visit said that any criminal offence had been committed. If you look at P4ET, please. At page 8. At 00:17:21, this is the conference on the 17th, so after Officer A and B. Officer A, who couldn't speak Albanian, and Officer B, who could, attended. And Mr. Gucati confirmed. Well, the journalist asked, did they say it's a possible criminal offence? That is what they did in the first and second press conferences. Mr. Gucati said, no, they did not tell me that it's a criminal offence. And Mr. Gashi, who had also spoken with Officer B by this stage, confirms at page 9, second paragraph, there were no talks, this is talking about the contact they'd had from Officer A and B. There were no talks about initiating the prosecution of anyone from the KLA Veterans Organisation because they have not committed a crime. So Mr. Gashi confirmed that when Officer A and B attended and Officer B spoke to them in Albanian, he didn't suggest that there had been any offence committed, which reinforces, and you'll understand at these purposes, because in due course I will make submissions on mistake of law, whether in fact that understanding of the law is right or not. I'm not necessarily concerned with it at this stage, although we say it is, and we say that's why it explains quite properly the SPO making it clear that Mr. Berisha committed no offence. But the point is that what took place after the first and second press conferences reinforced the understanding of the law that Mr. Gucati had, as did the way the press responded, as did the legal advice that they received after the first press conference. All reinforced that understanding of the law. And Mr. Gucati's actions, what he said and did, are entirely, we submit, consistent with that understanding of the law. I was going to refer to, take your honours to consider at this stage 14 names, because obviously the names were mentioned in the course of 3 press conferences. I'm going to do them, if I may, by reference to the final trial brief, and if I can find them in the exhibit so Your Honours can see them, then I will attempt to do that. So there were names mentioned in the first press conference. They were all Serbian officials. If we look at P1ET, so if Your Honours look at, if we scroll down to the bottom of page 1, please. Going on to page 2. So we can see Mr. Haradinaj mentions in the second paragraph, but the name I've already said it. Is there any issue about that name, Your Honour? Yes. There is.
Yes, do not name a name. We can read it. We can read it.
Well, there are two names there. One is the ex-Serbian war crimes prosecutor, name familiar to every person in Kosovo. And the second one is the chairman of the working group of the Committee of Kosovo Metohija in Serbia, again, public official. Then there's a reference at the end of that paragraph to Deputy Prosecutor of Serbia, and Your Honours can see the name there. So that's 3 names. If we scroll down further then, please. In the middle of that page, if we can just count the paragraphs, can we reduce to fit? In the 5th paragraph, there's the name of a deceased person. Is that a name that I can mention, Your Honour?
We can read it. There's no reason to mention it.
Well, he's obviously deceased, and I don't think anyone suggests that he is, for example, a confidential name in any way. If we carry on then, further. Next page then, please, I think. Next page. I hope. Go to the next page, please. Next page, please. Next page, please. Next page, please. Can you keep scrolling down, please, Madam Court? Up to the end. Can we go back to the start, please? Can we scroll down again, please? It's because we've got the redacted version. Can we have the unredacted version, please? Thank you. If we go to page, if we start scrolling down then, please. pause in there. So we saw, in paragraph 2, we saw 3 names that haven't been redacted. Then there's another name that was redacted, but we can see the unredacted form there. So that's 4. And then if we go down 3 paragraphs down, we see another 2 there. Sorry, 1 there. Former Chief of Police from Prizren. Next paragraph, we're up to 6 with Mitrovica, Chief of Police. And then we get 2 more in the next paragraph. We get this. The 7th then, sorry, the 9th, sorry, in the paragraph that begins, they've also cooperated with, and I've only picked a few as you only flick through them, and then there's a reference to former employer civil defence in Firizat. So 9 mentioned at the outset there, in that first conference, all Serbian officials. All mentioned, consistent with those same distinctions that Mr. Berisha made. In fact, Mr. Berisha himself published 2 of those names in the article that we saw. So 9. In the second conference, only 2 names mentioned. Again, both Serbian officials, one of whom is mentioned in the first press conference, so only 1 additional further name. And if we can look then at the transcript from the second press conference, which is P2ET, please. And if we look on the first page there, there were 2 names mentioned in the first press conference. These 2 are mentioned by Mr. Gucati. So in the first press conference, Mr. Haradinaj mentioned those 9 names of Serbian officials, albeit in Mr. Gucati's presence. In the second press conference, Mr. Gucati mentioned the only 2 names mentioned, the 2 Serbian officials. And the only 2 that he named. And one of them, again, was a name mentioned on the first occasion. You can see it in the 3rd paragraph from the bottom. A Deputy Prosecutor of the Special Court of Serbia. And then the only additional name, so the 10th name mentioned, in the 2nd paragraph from the bottom. General Director of Police in Serbia, and a member of the MUP. So that's the 10th name, again, Serbian official. So such names are mentioned in the first press conference and the second press conference, entirely consistent with that same distinction that Mr. Berisha made between persons who are public persons, such as Serbian officials, and people who are private persons. And Mr. Gucati confirmed his understanding of the law, and that he was acting consistently with it. If you look at T2192, sorry, T2192, please. if we look at line 2, sorry, line 16. So again, he's talking about 2 Serbian officials. Line 16, he said, we thought we did not do anything in violation with the law because they were public Serbian officials, and that's why we mentioned their names. So, there are 2 further names that Mr. Gucati did not mention, or Mr. Haradinaj did not mention, or anyone else from the KLA-WVA, but Mr. Gucati did, on his Facebook page, post a link to an article by Gazeta Newborn that did refer to 2 further Serbian officials. So these are numbers 11 and 12, if you count that as a disclosure by him, albeit, as I say, he didn't refer to them. These are names disclosed by Gazeta Newborn in an article they published online. The article is at P124. And just pausing there, you can see in the title in the Albanian that word, again, pardon my pronunciation, bashkëpunoj, which can either be interpreted as collaborate or cooperate. It's the same word. And we can see here it's interpreted in English this time as cooperated, but on other occasions it's interpreted as collaborated. But it is the same word, there's only a single word. But if we look at the Albanian article first, we can see that it's an article published by Gazeta Newborn, and on the first page there's an image of Serbian army officers. And we see that from the headline. And there's a reference to particular Serbian army officers, which if we scroll down, we can see there is an image online. It's a full unredacted version of coordination request number 95. In this printed version, because this is a PDF of what you can see on the screen, it's quite small, but you actually access the website itself. It's perfectly legible. It's a full copy of the coordination request number 95. It's unredacted. Published by Gazeta Newborn. And the letter is not marked as confidential. It refers to a confidential annex, but the letter itself is not marked as confidential. And it refers to 2 MUP war crimes liaison officers. And if we look at the English translation, we can see their names. They're named by Gazeta Newborn in the second paragraph of the article. They are 2 Serb officers present in some of the macabre massacres committed in Kosovo by the regime of a deceased person. And we all know who the deceased person is. It may be possible, in fact. Can I ask if Madam Court Officer can actually zoom in on the letter? You can see, as I say, when you actually look at the website itself, it's perfectly legible. And in fact, we will see in the exhibits coordination request number 95, and we will look at that later together. And you'll see, as I say, published in full, referring to MUP war crimes liaison officers and naming them. And no doubt, Gazeta Newborn applying exactly the same distinctions that Mr. Berisha had, that Mr. Gucati understood was the position confirmed by Mr. Gashi. Distinction, look at the document. Is the document itself marked as confidential? Look at the content, things that are confidential in it or not. Distinction between persons who are public persons, such as Serbian officials. And they published that letter. Why? Because it demonstrates the degree of cooperation between special investigators and Serbian officials. As Mr. Berisha said, was his explanation, and no doubt what Gazeta Newborn would say also. In fact, I found the reference to it. Can we look at P93, please? And we can see here the actual copy of the coordination request number 95. And in fact, you can see, and if you were to compare back, perhaps I'm not going to invite us to do it at the moment, but you can compare back and see no redactions applied in the version that was printed by Gazeta Newborn. In the third press conference then, there were two additional names that were mentioned that obviously, I concede, were not Serb officials. But they were both certainly public figures, and the press understood them to be public figures. If we look, please, at P35 ET, we will see that one of those two names, which will take the list up to 13. In fact, the name wasn't mentioned by either Mr. Haradinaj or Mr. Gucati. If we look at page 13, and we look at 002543, it's a journalist who raises the name. He asks whether, I'll call him X, whether X was referred to in the documents. The answer from Mr. Haradinaj and indeed Mr. Gucati over the page, both they say we don't know. Neither of them actually mention his name, nor say whether he's in the documents or not. So we can see Mr. Haradinaj's answer there. We don't know if he is. If you look at the top of the next page, Mr. Gucati says the same. We don't know about it. So 13 names, if you count him, even though neither of them actually mentioned his name or said whether he was referred to in the documents of batch 3 or any other batch. There was another name mentioned, so this will take us up to 14. And you'll have to bear with me while I find the reference. Can we go earlier on, please, Madam Court Officer? I need to find his name, only to show it to you, Your Honour. So if we can go back to the start, I'm afraid. And if we can just scan down. Next page, please. 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 And further again, please. Next page, please. again, please. And again, please. Tell you what, we'll do it another way. You'd have to just trust me on this. If we look at T1313, we'll see the name that I was looking for, and then Your Honour can see it, and you just have to look in due course to see whether his name was mentioned in the third press conference. So if we scroll down, in fact, we're not going to see his name here either, because we weren't allowed to refer to it at that stage. Perhaps if we break at this stage, an early break, and we can think of a way of identifying for you the person that we're going to refer to, and I'll continue at that stage.
All right, we will break, be back at 2 o'clock, at 2:30. And we will be ready to proceed at that time. We are in adjournment.
All rise. All rise.
Be seated. All right, Mr. Reese, you may proceed.
Your Honour, if we could
Continue.
look, please, at transcript T1791. So 1791. So, Madam Court Officer, that's the public version. Thank you. And if we look at line 20, Your Honours will see the name of the 14th name that was mentioned. And we can see there that, although not an SPO official, certainly a very public person, as Mr. Jukic accepted, acknowledged, to his knowledge, that person was somebody who had made it very public for a number of years, dating back at least to 2012, somebody who has made it public that he had been cooperating with the investigators, prosecutors, investigating alleged offences committed by the KLA. He acknowledged. So, only 14 names mentioned by Mr. Gucati or by Mr. Haradinaj in his presence, or the two names referred to in a Facebook link to a Gazette Newborn article, and one name of which a journalist asked about, even though Mr. Gucati and Mr. Haradinaj said they did not know whether his name was in the batch 3. All of them, each and every one of those 14 names, public figures. So I submit Mr. Gucati's actions, words, entirely consistent with that understanding of the law that Mr. Gucati had expressed and shared with the public, with the press, shared by Mr. Berisha, shared by the lawyer Mr. Gashi, reinforced by the actions of the SPO when they came after the first and second press conferences. None of the named Serbian officials, none of them, contacted the SPO with any complaint about their names being published. Or at least there's no evidence that any of them did. If we look at page 1793 of Mr. Jukic's evidence, at line 4, and your Honours will recall that I'd gone through the names previously with Mr. Jukic. Of the names that were published, you can only help us with one. Through to line 5 on page 1785, you can see that he was specifically asked about those names. The only one that he could confirm didn't was the first. The others couldn't say. As I say, he then went on to say that he could only help with the one name. So no evidence of any of those named Serbian officials making any sort of complaint.
Mr. Rees, you named the name again on line 19. It'll have to be redacted.
Sorry, what? I named... Sorry, Your Honour. I named what, sorry? At what page?
Previous page.
Well, I apologise for that, Your Honour. I have throughout the trial done my best to follow, but sometimes these things happen. I apologise. In relation to the name which we see at page 1792, line 24, in relation to that name, again, he was not a person who made any complaint about his name being mentioned, because we can see over the page that, in fact, he was somebody who the SPO was no longer in contact with anyway by then. So, none of the Serbian officials, no evidence they made any complaint. The person, public person, named, we see in the transcript of page 1792, line 24, he never made any complaint because he wasn't in contact with the SPO anyway at that stage. And if we look at line, page 1904, the bottom of the page, they're going to have to start actually at the bottom of page 1903. Your Honours will see at the bottom of that page that Mr. Djukic was asked about the name that had been discussed at page 27 of the draft transcript. That is the name that he had said was very public, had made very public for a number of years, dating back at least to 2012, that he'd been cooperating with the investigators, prosecutors, investigating alleged offences committed by the KLA. That person, we'll see at the bottom of page 1904, although he contacted the office, he did not express any concern for his security. We can see it at line 11. He was asked, Mr. Djukic, whether that person had expressed any concern for his security or had received any threat. The answer was, at line 20, can't recall exactly what he said, so no evidence that he did complain about concerns of security or receiving any threat. He was complaining about publishing of the leaked documents. At the bottom of the page, the SPO didn't take any measure to protect this particular individual. So of the 14 names that were either mentioned by Mr. Gucati or by Mr. Haradinaj in his presence, or the two names referred to in the Gazette of Newborn article that Mr. Gucati put a Facebook post linked to, or the name of the public person that a journalist asked Mr. Haradinaj, Mr. Gucati about, and they said they didn't know whether he was named in batch 3. Of any of those names, There's no evidence that any of them made any specific complaint about any fear for their security or threat or at all, and no evidence that any protective measures were taken in relation to any of them. That is the evidence of Mr. Jukic in relation to those names, the only names that the SPO identify as having been mentioned in public. And despite the broad brush approach that the SPO take, when you analyse, scrutinise the evidence such as there is as to the consequences of Mr. Guzzati's words and actions, it's our submission that, on a proper analysis, that evidence is underwhelming to say the least. Firstly, the SPO has called no evidence from any alleged witness themselves as to consequences. There is no admissible evidence that any of them were threatened, or indeed felt threatened, were harmed or felt harmed, were afraid or felt fear, were intimidated or felt intimidated. No admissible evidence from any alleged witness or at all. To the extent that the SPO were permitted to adduce any evidence of complaint from an anonymous third party, because whatever was suggested in terms of complaints, they were by anonymised third parties. To the extent that they were permitted to adduce any such evidence, that evidence was not admitted as truth of its contents, as evidence of the truth of its contents. That is, not admitted as evidence, for example, that any anonymous third party was afraid or had actually suffered any harm. And that was the consequence of Your Honour's rulings at filing 00334 at paragraphs 90 to 94, as reaffirmed in the transcripts at T1737, T1743 and T1754. The sole purpose for the admission of evidence of any such complaint, Your Honours held, was for the limited purpose of describing the procedures followed by the SPO in interviewing these witnesses, as well as the resources used and time spent on such interviews, to the extent that such witnesses have knowledge of such matters, such witnesses being SPO officers. That is, the sole purpose for the admission of any evidence of complaint was to demonstrate the degree of inconvenience caused to the SPO rather than the truth of the contents of any complaint. Properly analysed, the evidence reveals, we say, the following. Can I ask if we look, please, at transcript page 1795. At line 15, going over the page, we'll see in a minute, to 1796, line 4. So if we go back to 1795, line 15, we'll see that there was no specific action taken by the witness and security handling team after the 16th of September. That's the question. Sorry, after the first press conference on the 7th of September. No, there wasn't, is the answer. And again, if we go over to the next page, we'll see that again, there was no action taken by the witness and security handling team after the press conference on the 16th of September. So, no specific action taken by the witness security handling teams after the first and second press conferences. It was not a high priority or a priority at all for witness security. And there's no evidence that the other teams within the SPO regarded the first and second press conferences as leading to consequences in relation to which it was a high priority resolve. If we look, please, at T1797. At line 25. Mr. Jukic was talking about how the SPO, or his knowledge rather of the SPO and its priorities in September. And at the last line on that page, it was put to him that he didn't know what, if we look at the top of the next page, to what extent it was a priority for other teams within the SPO. All you can say is that as far as the witness and security handling team is concerned, the 7th and 16th of September press conferences did not create a high priority. I don't know, I can't answer. So all you can answer is in relation to your experience with the witness security handling team. Is that fair? Yes, that's correct. And we know that Miss Pumper was not asked to do anything either. As far as the witness security team was concerned, they did nothing after the 7th of September press conference, and they did nothing after the 16th of September press conference. And, of course, there were 2 orders applied for after the first and second press conferences. But Mr. Officer A, the Swedish officer, accepted that on both occasions, certainly in relation to the second, he could recall there being a telephone call to the KLA-WVA and him agreeing that they wouldn't go around that evening, they would leave the documents where they were, and they would come the following day. And he accepted that that was probably the same chronology after the first press conference. As far as Mr. Moberg was concerned, he was content. As far as the Swedish officer was concerned, he was content for the documents to remain with the KLA-WVA overnight. And indeed, the orders themselves do not suggest any particular urgency or priority because they gave up to 5 days for the orders to be carried out. So if we look at P52, please. So we can ignore the Albanian because that wasn't translated, as we can see, until days afterwards. So we only need to look at the English. And if we look at paragraph 15, we can see there at the end of paragraph 15, the single judge gave 5 days for the issuance of the present decision and the execution of the requested seizure. And if we look at P53, and again, go to paragraph 15, please. We see again, same terms, end of paragraph 15. Single judge finds that 5 days from the issue of the present decision is sufficient for the execution of the requested seizure. Can we go back to T1799, please, and Mr. Djukic's evidence then? Mr. Djukic, having said that the witness security team didn't do anything after the first press conference or after the second press conference, and couldn't say whether any other team did, there wasn't even much discussion about witness contact in the days after the first and second press conferences. At line 15, he asked to clarify the general evidence that he gave in direct examination about there being a lot of discussions about witness contact notes. Line 18, he was asked, I'm going to ask you to confirm or reject the suggestion from me that when you talked about there being a lot of discussions about witness contact notes, that must have been at the time or after the formulation of the 24th of September plan. Do you agree with that? Yes, I agree. Thank you. So there wasn't a lot of discussion about witness contact notes in the days after the 7th of September press conference. Is that right? If we can continue to the next page, please. That's correct. Or indeed after the 16th of September press conference. Do you agree? Yes, I do. So there wasn't even much discussion within the SPO, certainly within the witness security handling team, about what had taken place on the 7th or the 16th of September, and they didn't do anything about it. After the third press conference, we know that a decision was taken to contact each person on a list that was presented by Mr. I can't say his name, by the officer who was the leader of the witness security handling team at that time, the predecessor of Mr. Djukic in that role. And if we go to transcript page 1804, so we see there the name of that team leader, in fact. And he was talking about what plan was formulated after the 22nd of September press conference. And on the 24th, if we go over the page, in fact, I think, we see that at line 9 onwards, So we don't know actually how that list was produced or what was the basis of it. But it was a list of names that the witness security and handling team were to contact. And that exercise, which, as the evidence went on, you recall, began to be referred to as the 24th of September exercise. The net effect of that exercise was that it involved approximately 200 telephone calls. If we look at page T1824, please. So, in the middle of that page, roundabout from lines 15 onwards, we can see that he confirmed that as part of that specific exercise, the team was involved in around 200 phone calls. And that took, or rather the SPO were busy at least with that exercise, for approximately 2 to 3 days. If we can look at page T1838, please. So at line 22, as I said, Mr. Dukic said, we were very busy for 2-3 days with the phone calls. So nothing after the first press conference, nothing after the second press conference. After the third, Mr. Dukic was told, as were the members of the team, to contact everybody on a list that had been prepared. Single complaint, whether true or false. Not a single complaint was recorded as involving a direct threat being made to a person which could be attributed in any way to Mr. Guzzati's actions. There was a suggestion made at one stage of 2 complaints of threat. If we look at T1834, please. You were asked, the question went line 2, how many of these persons told you that they'd received threats in or after September 2020? And you said, I can't recall. Yes? Answer, yes, that's correct. Is it still the case you can't recall? I can recall majority but not numbers. Question, well, you say that today. What you actually said on the 28th of October when you gave evidence was when you were pushed, just to say roughly, you said very few. And we saw that in the transcript, in fact, in the prosecution's referred to it in their presentation yesterday. And Mr. Dukic agreed there at line 14, yes, he had said very few. And then at line 18, he was asked to describe how many is very few, and he said at line 19, 2. And indeed, there had been 2 contact notes that had been disclosed, which Mr. Dukic had been referring to. One, at line 23, we can see, it was put to him that it involved a posting on a Facebook post on the page of Kosovo Press. He said that he can't recall. If we can go over the page, please. Because he couldn't recall, he was shown the document at line 9. And at lines 10 to 14, he accepted he could see that the document was on dated the 7th of September, referred to a link to facebook.com and a page for Kosovo Press. And then there was an opinion from an unknown person reporting that person's opinion on what the 7th of September amounted to. And that was one of the documents. The second, if we carry on, please. If we go to T1837, line 1 there, the second matter that Mr. Dukic was referring to, as we could see from the contact note, was somebody who claimed that they'd received a letter with a threat if he was going to be a witness. He was asked for the letter, he couldn't produce it. So the question was, there must be some doubt as to whether this letter was in fact received by him. But he didn't say himself that that referred to events arising out of September 2020 in that record. And the answer was, he doesn't. And he doesn't claim that the author of the letter, if indeed there was a letter, said anything relating the letter back to the events of September 2020. And he agreed. So, those two matters, one was simply the opinion of a reference, to the opinion of someone else expressed on a Facebook post as to what the events on 7th of September amounted to, although we don't have evidence as to specifically what that was. And the second matter related to a letter, but there was no link either by the person making the complaint about the letter or in the letter itself, if it ever existed, to the events of September 2020. And indeed, it had appeared, at least from the SPO's final trial brief, although not entirely clear what the position is now after the statement yesterday, but certainly in the final trial brief, it did not suggest that anyone had received a direct threat as a result of Mr. Gucati's actions, or indeed Mr. Haradinaj for that matter. Of the other complaints recorded or reported during the trial, although not admissible as evidence that they were true, Ms. Pumper gave evidence of contact with two persons. If we look please at transcript page T1385. And at line, so 1385, please. So, at the beginning of this page, Ms. Pumper was reminded that at the close of her direct examination, she referred to speaking to 2 witnesses or potential witnesses, one of whom she had said had shown concern. The first of those 2 witness contacts she was asked took place on the 17th of December. She couldn't confirm the date, but if we go to the next page, having been shown the official note to remind her at line 18, she was reminded from the note that there was a meeting 17th of December 2020, 2 other SPO officers, one of which was Mr. Dukic, 2 interpreters, phone call. That reminded her, she said, I recall the participants, yes. And then over the onto page T1387, continuing to talk about the contact note. Witness, according to the note, said he was aware of the dissemination but not aware his name was in any of the documents. And Ms. Pumper said if that's what's written there, that's correct. And if we go on to T1388, she confirmed that, in fact, that person said they did not have any information about the matter and they did not have any security concerns. And she confirmed that that's what the witness had said. If it's written there, she said it's accurate at line 7. So, of the 2 contacts that Ms. Pumper referred to, one said they did not have any security concerns. The second matter, if we look at T1388 line 11, line T1841, please. Sorry, T1841, line 14. Now, I'm going to use, if I may, the letters A through to L. But we can see lines 14 to 17 there. The person A, this is the person that had said he was a little bit worried about the general security position, which is referred to in the SPO's brief. But that person hadn't noticed anything suspicious, and he hadn't had any problems since they last met. That was a routine meeting, he said. At T1845, please. Lines 2 to 5. The person B was told by Mr. Djukic that the documents were public, old ITF documents. There was nothing from the SPO era, and there was nothing in the files that actually related to it. And that made B a bit calmer. At T1855, please. Line 13 to 16. This is somebody, C, who had asked to be relocated with his family, Mr. Djukic had said, but that was not because he had been called or approached by anyone, because he hadn't. And we can see that at lines 13 to 16. And on the same page, if we go down to line 22 to 24, the next person, D, he confirmed that he too had not been called or approached by anyone either, in a short call that lasted approximately 10 minutes. The person E that Mr. Djukic spoke to, if we look at T1859, please. At line 4, person E was spoken to. I think if we just go slightly smaller, on the 3rd of October, according at least to the contact note, he too said, according to the note, that nobody had approached him or threatened him, and he doesn't feel threatened. Mr. Djukic confirmed. At page T1861, next please. At line 7 to 9, F, the individual F, said that he heard rumours, but he had not actually received any threat himself, we can see. At T1867, line 17, the individual G was recorded as saying he didn't care about what had happened, and that he hadn't received any threat and he didn't have any security concerns. Over the page to page 21868, at line 6, individual H, he also said, according to the note, he wasn't worried, he hadn't received any threat, and he didn't have any security concerns. T1869 then, please, line 3. Individual I was recorded as saying he's not afraid. He didn't have any security concerns. In fact, he said he was never threatened after the war in Kosovo, and the only threat for him was Serbs during the war. Is that right? He was asked. Mr. Dukic said that's what he said. Then at T1877, please. At lines 14 to 19, individual J, according to the note, when asked if he'd been contacted in the last weeks before the 26th of October, whether anything had caused him concern, he said that nothing had happened, and he didn't expect anything to happen. Then to page T1878, please. Lines 1 to 4. Individual K was contacted, and she said she hadn't received any threat. And then finally, of the contacts that Mr. Dukic had, at T1882, please. Lines 10 to 14. The son of Al, who contacted the SPO, they said they did not need any help, and they didn't express that they were scared. Those were the contacts that Mr. Dukic had. And although he was ready to make general assertions, which the SPO rely upon, when scrutinized and the detail looked at, our submission is it did not amount to much. He gave evidence to the effect that the SPO had to provide a small number of new telephone numbers to witnesses in the months after September 2020. They'd also done that before the events of September 2020 as well. If we look at page T1882, please. At line 22. Sorry, line 18 first. Question, you said in evidence last week that in relation to measures that were taken as a result of the September 24th exercise, some witnesses who weren't able to contact you, we provided them with phones. Can I ask you again, perhaps you've had time to think now, how many witnesses, individuals that you had contact with were provided with the phone prior to September 2020? Answer, maybe 1 or 2. And then over the page, please. How many after? Can you say or can you not remember? Let's say between 5 and 10, he said. I really don't know the exact number. And we didn't have any records produced to assist one way or the other. So a small number of new telephone numbers before a small number after. And similarly, there were a small number of emergency risk management plans in place before, and an unspecified number after the events of September 2020. If we go to T1885, please. Line 21. Question, were any emergency risk management plans already in place for any witness before 7th September 2020, in the 2 years before 7th September 2020? And continuing over the page, please. Yes, there were 2 or 3 emergency risk management plans in place. Do you keep a record of those plans? Yes, we do. But, he continued, don't have records of the decision-making process, creating such plans. And we never did get a number for emergency risk management places after September 2020. And he produced no records, the SBO produced no records in relation to, for example, the allocation of new telephone numbers or emergency risk management plans to support the proposition that any such measure was taken in response to Mr. Guzzati's actions. Similarly, no records were produced to support Mr. Djukic's late assertion, very late assertion, that a relocation or relocations were required as a result of the events of September 2020. Mr. Djukic did not, in any of his declarations, refer to a relocation. If we look at page T1889, please. At line 11, in your October declaration, you did not say anywhere that the SPO had to relocate any witness as a result of the events of September 2020. Do you agree with that? I agree with that. And in your January declaration, you did not say anywhere that the SPO had to relocate any witnesses as a result of the events of September 2020. Do you agree with that? Yes, I do. The suggestion arose for the very first time in the witness preparation session that Mr. Pache and Mr. Halling conducted with Mr. Djukic on the 14th of October 2021, shortly before he gave evidence. And at that stage, he referred to one relocation, moving someone to a safe house. We see that confirmed at T1902, please. Lines 2 to 5. Mr. Pache, I think it was, read to him the content of the note that Mr. Pache, I think, had prepared, or either Mr. Pache or Mr. Hallin. Such measures included, we see at lines 3 to 5, 1 relocation, comma, moving someone to a safe house. In evidence, that became 2 relocations, although the explanation that is given as to why he appeared to have said only 1 relocation to Mr. Pache and Mr. Hallin, well, it'll be a matter, of course, for the trial panel, but I make this submission. It's difficult to follow any real explanation. Mr. Pache asked Mr. Djukic, specifically here, we're talking about 1 relocation and someone being moved to a safe house. Answer, yes, that's correct. 2 persons. Mr. Pache continued, in terms of moving someone to a safe house, are you distinguishing that from a relocation? Or is it essentially the same thing? It's the same thing, which of course does look exactly what it is, 1 relocation, moving someone to a safe house. Could you explain why, at least as reported in this note, Mr. Pache continued, did you distinguish at one stage between 1 relocation and moving someone to a safe house. Is there any difference that you can think of? Is there any, and if relevant? The relocation we did was direct. Directly, person was extracted out of the house, moving in the safe house. Person was extracted from their home to the safe house, and afterwards extracted out of the Kosovo. So, no real explanation at all as to why it appeared to be one relocation in the note that Mr. Pache had recorded, 2 relocations he mentioned for the first time in evidence, and no attempt to explain, or any attempt that can be borne out to explain that inconsistency. And of course, there were no records in relation either to 1 or 2 relocations produced by Mr. Dukic to support his proposition that arose very late, that such a measure at all was taken as a consequence of the events of September 2020. Remarkable, one might think, when he had been specifically asked to make 2 declarations, one in December and one in January, setting out the consequences of the events of September 20. Remarkable that he did not mention until he spoke to Mr. Halling and Mr. Pache in relation to 1 relocation, and then evidence 2 relocations, both of which he said in evidence, although without anything to support it, took place before both his declarations were produced. Mr. Dukic, as well as the late claim that there was 1 or 2 relocations, also claimed in evidence that one anonymous witness commented to him, "I know very well what happened to witnesses in Kosovo," which is something the SPO in their trial brief rely upon. But again, he was confronted about that assertion, because that arose the very first time in his evidence. Never said anything like that before. And when confronted about his records, he conceded that it's not recorded anywhere that a witness had ever said that. And we see that at T1880, lines 20 onwards. We can see there in line 20, and in none of those notes do you record a witness saying, "I know very well what happened to witnesses in Kosovo." You don't record that anywhere in the contact notes. They're not in these contact notes. The evidence of Mr. Dukic was neither clear nor unequivocal, as the SPO have asserted. Such records that he did produce were characterized by inconsistent dates, with no sensible explanation given as to why. He gave evidence, if we look at T1771, line 23 first. He had said earlier that every contact with a witness was documented in an official note after every phone call. It was his initial assertion. But that simply did not correspond with the dates on the official notes, because some were dated days, some dated weeks, some dated months, in fact, after the alleged contact recorded in them. If we look at T1846, please. at line 13, in relation to a note. This one dated apparently 25th of September, but referring to events on the 8th of September and the 22nd of September. At line 13 was asked, so are you, Mr. Djukic, are you saying that you made this note of events on the 8th of September, or on the 22nd of September, or a short period later on the 25th of September? And he said, yes, I made this note on the 25th of September. Right, the question continued. So just so we understand, your evidence, you record official notes immediately after every phone call and meeting. You accept that that's now wrong. Do you agree with that? That's right. So he abandoned the initial position that he asserted, but that perhaps you would expect that there would be a contact note made immediately after every phone call and meeting. Indeed, of course, as we've just seen there, that couldn't be right, not only because some were dated later than the last alleged contact in the note, but a single note would often record a contact on a series of different days, as we had just seen. When confronted with the discrepancy in the dates at the top of the documents, he initially attempted to suggest that whereas, for example, some documents allegedly referring to alleged events in September and October 2020, in fact had a date in February and March 2021, his initial attempt to explain that discrepancy was that because of COVID, the notes had been made contemporaneously with the meetings, but he wasn't able to submit them in timely fashion to Xylab because he was not allowed back to the office. Well, he abandoned that. Again, so a second position he abandoned when it was pointed out to him that there was evidence that, of course, he was in the office long before the dates belatedly put onto those notes. If we'll have a look, please, at T1849. At line 9. So this is a document that had the 15th of March 2021 on it, although purporting to deal with events, I think, in September. Last week you were saying, the question was, that there was a delay in submitting documents to Xylab by you because you weren't in the office, blaming the pandemic. Is that right? Yes, that's correct. But we saw you in the office earlier on the 27th of October 2020, didn't we? Yes, that's correct. Yes, so if this note predated that, why didn't you submit this note on that date? So you abandoned that position and instead then sought, well, he gave this explanation. We asked the witness security team leader to send official notes, and he was supposed to submit them in Xylab. So it wasn't to do with COVID and the pandemic. It was, although he did not accept that this was the effect of it, but it was an attempt we submit to then blame. He accepted that he had applied the dates in February and March. And our position was put to him, and it's right that Mr. Jukic denied it, but we suggest that what was put to him is the inference to be drawn, in fact. It was put to him that he was asked in February to start putting together notes. And he realized that there were notes that he had not made of witness contact, so he started preparing them in February and March, and that's why they were dated months after the events. Now, he did not accept that, but he gave no real explanation, no real alternative explanation for those errant dates. And make this observation, if I may. If there were similar discrepancies in dates of records adduced on behalf of Mr. Gucati, by Mr. Gucati, or by any of his defence witnesses, you can no doubt bet that the SPO would not dismiss those discrepancies as lightly as they wave them aside in relation to Mr. Jukic and his credibility and his reliability. And we submit that Mr. Jukic's evidence is to be adjudged by exactly the same fair standards as will be applied, I have no doubt, to the evidence called on behalf of and by Mr. Gucati. On one occasion, Your Honours will recall that Mr. Jukic, being aware that he was only allowed to give evidence about contacts which he was involved in, which he was present at with a witness, he claimed that he was present at a contact, so he could describe the contents of the note, even though the record made it perfectly clear that he was not there. And you'll recall that, and it's at transcript page T1750. It is our submission that his account of the consequences of events of September 2020 is both, as it happens, underwhelming and, in any event, unreliable. Specifically, he gave no evidence, and the prosecution have called no other evidence, to the effect that any specific investigation or prosecution has actually been adversely affected by what took place in September 2020. Certainly by the actions of Mr. Gucati. No evidence of any specific investigation or prosecution being adversely affected. And nor does that evidence, the evidence called by Mr. Jukic, that they did nothing after the first press conference, they did nothing after the second press conference, they did after the third go through a list of witnesses. After being told that nothing in the files related to them. No one had been called or approached by anyone directly. No one had received any threat. Numbers didn't have any security concerns. They didn't need any help. Didn't express that they were scared. Those contacts that, on analysis, we went through carefully, that evidence doesn't amount to evidence of a current climate of witness intimidation, which no doubt is why the SPO rely on events dating back some 10 to 15 years. at this point, before I move to, if you like, making legal submissions, I know it's early, but perhaps I can ask for an early end to the day today. I don't have much longer, but I certainly won't be finished by 4 o'clock, and we'll go sometime after that. I would rather do those submissions in one go tomorrow rather than begin them and then stop in flow, as it were.
Give me your best estimate of time.
An hour.
We'll adjourn till tomorrow.
Thank you.
But just before we do that, just on the issue of the witness statements that we've asked for and you've both filed, and I appreciate that. Mr. Cadman, the sole objection to the proposed witness statements for the session devoted to sentencing submissions was your tendered statement number 574. Do you still wish to submit that?
I do, Your Honor.
And have you looked over, perhaps, I was looking at the second page of the statement, and there's 2 paragraphs about a third of the way down that deal directly with issues of nonviolence, and which I think would be acceptable to the prosecution. But at any rate, if you will file by 4 o'clock tomorrow a short written submission on that particular item, that's all that's required. We'll make a decision based upon that.
Second.
All right. Anything further from anybody?
No, Your Honor, thank you.
Thank you, Mr. Reese. Anything else? Thank you. We will be adjourned, and we'll see you here tomorrow morning at 9:30. Thank you for your candor today and submissions, and we wish you a good evening.
All rise.